You need to check out the call. Let you are on YouTube on. So here you go, sir. Sir, here is the first question, sir.
Good evening to all of you. The questions are very, very simple. The answer also is contained in the question itself. Here, the facts of the case are that there was a money transaction between A and B. A borrows 50,000 rupees from B and executes a promissory note and receipt, and A files a suit for recovery of money. What is the limitation for filing a suit, and what are the defenses that can be taken by the defendant on the other side? Again, I repeat the question, sir. A files a suit for recovery of 50,000 rupees against B, who has borrowed the said amount and executed a promissory note and receipt, and A files a suit for recovery of money. What is the limitation for filing a suit, and what are the defenses that are open to the defendant? It's a simple question, sir. Answer is also contained in the same question.
Have you people understood the question?
A suit based on promissory note.
All right. Sir, Raviraj Garu. Raviraj Garu, you are for A.
That is plaintiff.
Plaintiff. And Jagdishwar Garu, you are for? Raviraj Garu, no. Jagdishwar Garu, you are for defendant. Can you put your arguments on this particular case?
Suit based on promissory note. A files a suit for recovery of 50,000 rupees from B, and B executes a promissory note and receipt in favor of the plaintiff, and plaintiff files a promissory note and receipt in the court. And what are the grounds of attack as far as the plaintiff is concerned? How does the plaintiff maintain the suit? What are the arguments which he will advance in regarding his suit, sir, as a plaintiff? If you are the plaintiff, what will be your arguments?
Sir, anybody in the class? Will you take the challenge?
What is the limitation period?
3 years, sir.
It's 3 years.
Exactly, you're right. Then what are the grounds of attack on which the plaintiff can rely? What is the document on which the plaintiff can rely to maintain his suit, sir?
Non-payment.
One by one, sir. We'll pick you up. Srinivas Reddy, sir, please. Srinivas Reddy, sir. Alright, I hope he is not answering. Now I'll take Salina, madam. Can you explain it?
What is the period within which the suit has to be filed? I'm putting a simple question.
You can unmute yourself and you can answer the question. But before you unmute, please raise your hand. Salina ji, please. I think it's not possible to answer this question from her. Anybody else?
Again, I repeat, what is the period within which a suit has to be brought based on the promissory note on behalf of the plaintiff?
3 years from the date of denial, sir.
Exactly, you're right.
3 years from the date of denial by the defendant.
Exactly.
Can you be a bit loud?
3 years from the date of denial from the defendant, sir.
You are absolutely right. What are the documents you filed into the court?
Promissory note, receipt, acknowledgement,
Yes.
and if at all some notice is given to him to
Yeah.
make the payment, that also need to be given so
You are
that
absolutely
to
right.
identify the date of
Yeah, you are absolutely right. Within what period you said? 3 years, right? Then
3 years.
3 years. You are right, sir. Then the question is, what are the documents you filed into the court along with the claim, sir? The foundation of your claim, what are the documents called?
Promissory note,
No, sir, you're
acknowledgement,
saying you're right. But what are they called in law? Are they called suit documents or are they called evidentiary documents? Or can you file the suit without filing the promissory note into the court? Can you file the suit without filing the promissory note?
the
Is
promissory
it-
note need to be filed, sir, along with the
If
petition.
you don't file it, will your suit be admitted?
No, you cannot.
You're right, absolutely right. I'm really happy that you have answered it correctly, sir. It's a very simple question, sir. Now the defendant, sir. What are the defenses that are open to the defendant in a suit for promissory based on promissory note? Anyone can take the challenge. Anyone can appear for the defendant.
And you can argue the case.
Defendant may claim that he has not taken the money at all.
What
And
is
it is only false document and
what is the second
it is
second
only
defense?
fake document.
It's you are trying to say it's a forgery. You are trying to say it's a forgery. You are trying to say it's a forgery.
Yes, sir. Yes, sir.
The third one is in the NI Act. There is one more defense, sir. There's material alterations. Material alterations.
Okay.
Then plea of limitation. Am I right?
Yes, sir.
Okay. Sir, this is based on a negotiable instrument, sir.
NI Act.
NI Act. A issues a check for 5 lakhs to B and the same gets bounced. Within what time a notice has to be given under section 138 NI Act? What is the time limit within which a notice of demand has to be given?
Within 1 month, sir.
I'm sorry, sir, it's 15 days, sir. 15 days from the date of bouncing, you'll have to give a notice.
After waiting the 1 month,
Exactly. You're right. Within 1 month, you must file a complaint. In other words, it is 1.5 months altogether, right?
And sir,
First is 15 days from the date of dishonor. That is over. And after the 15 days period is over, within 1 month, you must file the complaint. Okay.
do we need a letter from the bank that the check was disappeared?
Can you be bit loud? You are not audible.
Do we need any letter from the bank that the check was dishonored?
Not necessary, sir. But the day of dishonor is discounted. From the next day, it is 15 days notice has to be given. After 15 days, within 1 month, the complaint has to be filed.
and second notice need to be given or
Not necessary, sir. There is one judgment of the Supreme Court which says the second notice is not maintainable. The judgment of Justice K.T. Thomas.
Okay, sir. One is enough.
One is enough.
Thank you.
There's a small announcement. It's a practical experience. What you go, we are going slowly. If you leave the session, that will be problematic for you because we are coming with different kinds of suits also.
So, third question is, what are the ingredients that has to be satisfied before before filing a complaint? What are the ingredients under the Negotiable Instruments Act? And if so, under what section the ingredients have to be satisfied? I narrated it so many times, sir. Can you tell me, sir? What are the conditions that has to be satisfied to maintain a complaint under 138?
Kindly
And what is
clarify.
what is that section where the conditions are imposed? Yes.
Salina will come to your question. Please be and we'll clarify your doubt right today.
Offer and acceptance is a must.
Sir, we are not on contract, sir. What are the ingredients that has to be satisfied for maintaining a complaint under 138. There is a special provision also which says those conditions have to be satisfied. What is that section which says what are those conditions? Whether you can give a notice without any liability. I'm putting it, giving the answer also to you. And if so, under what provision?
Anuradha garu,
Any you're not able to answer. That is 142, sir. There must be a pre-existing pecuniary liability towards which the check was given and the check got bounced. Unless 142 is satisfied, 138 is not maintainable. Right? 142 is the section.
section 142 be satisfied, then only section 138, that is pre-existing liability, should be there.
Sir, again, the next questions of the defendant is, what are the defenses that are open to the accused in a case under the NI Act? What are the defenses that are open to the accused in a NI Act case? Can you name few?
Suit was filed before the notice period.
Right, premature. Right, next. You are forgetting about the check. I repeated it so many times. Material alterations. Material alterations regarding the date, regarding the signature, and regarding the person who is entitled to the check also. Some corrections are made, interpolations are made. That vitiates the check and the complaint is not maintainable, sir. Or it is barred by the Contracts Act where the ingredients are not followed. Then, sir, the third question is, what are the ingredients that has to be satisfied for filing it? I have already dealt with it. And what are the defenses for an accused in such a complaint? What are the defenses open to the accused? What are the defenses open to an accused in a complaint under 138? Please try and reply, please.
Sir, this is not oral arguments. What we will do, these are the questions you're going to face in the court also.
We are just introducing the subject to you, sir. That's the reason why the facts again will cover it in the next class. But here, what are the defenses that are open to the accused to face a complaint before a criminal court under NI Act? What are the defenses that are open to the accused?
That specific check was not given.
Hello, sir.
That specific check was not given.
What are the defenses that are open, sir? You answered
Hello,
it.
sir. Hello.
What are the defenses that are open to the accused?
Sign on the check is taken forcibly
Yes.
or forced sign.
Right.
Hello.
Next.
Sir, am I audible?
You are.
Yes, sir. Please go ahead.
Sir, sign on the check is taken by forcibly
Right.
or it is a forced sign.
Then what about the date? Date on the check? Date has been altered. Date has been altered.
Yes.
Third one is the interpolations are there, corrections are there. And ingredients of 142 is not satisfied. That is pre-existing monetary liability. And next, only as a security and not towards the loan, right?
Second scene was read again. Enforceable. Second is legally enforceable liability.
Exactly. That's what 142 says, sir. You're right. Then, sir, what are the? Then next one is can interim compensation be granted in a complaint under 138? Can interim compensation be granted under the NI Act to the complainant?
Yes, sir.
It is a new provision, sir, 144 of the NI Act.
143.
Exactly, sir. Can evidence affidavit be filed in a case of NI Act? Can evidence affidavit of the complainant or whomsoever it may be, is it permissible? Can evidence affidavit?
Yes, sir. It is permissible.
It is permissible. Right, sir. I just put a question to you, sir. Suppose interim compensation is awarded and the accused pays that money, and in case he succeeds in the complaint and the complaint is dismissed, what would happen to the interim compensation? Has it to be returned or not?
Return the complaint should return the amount to the accused, my lord.
You're right, sir. You're right.
Moral compensation amount should be in the deposited in the court account.
Sir, not necessary, sir. If you see the NIF, it should be paid and they deposited in account.
We can withdraw by the complaint at the time of trial.
He can withdraw. But one thing is this: suppose the accused succeeds in the complaint, is the compensation liable to be returned?
Yes.
You are right.
Complaint return.
Exactly, sir. Within what time?
Depend on case to case.
Not depending, sir. The provision itself is clear. Within 6 months from the date of order.
Okay.
Then, suppose, let us say, you appearing for the accused, you fail in the lower court. A sentence is passed against you, sentence of imprisonment as well as fine is imposed. Suppose you want the suspension of the sentence, how much amount you have to deposit in order to get the suspension? How much
20%.
amount? You're right. And then, sir, can the complainant withdraw that money, sir?
Yes, sir.
Next one is, we have discussed specific performance in detail, sir. What is the limitation within which a suit for specific performance has to be filed?
Within 3 years from the date of notice.
Right. There is an exception also to that in the form of a proviso. What is that proviso, sir, under Article 54? Sir, you are answering it in part. 3 years if the date is fixed, and if no time limit is fixed, it is 3 years from the date of refusal or inability on the part of the promisor to perform the promise. Right? Sir, what are the ingredients you have to satisfy to maintain a suit for specific performance? Sir, what are the conditions?
Sir, excuse me, sir. Just in the before question, in the contract it should be mentioned as and when required, right, sir?
Exactly.
Then only this provision will.
Then what are the steps you take? Suppose the word as and when called upon. Should you give a notice or not give a notice?
We need to give a notice.
Exactly, sir. That gives you
Notice
the
will be
extended
given.
period, sir. Suppose I put an hypothetical question. Suppose the original contract is novated, it is substituted by a new contract. Which is the contract which has to be performed? Is it the original contract or the substituted contract?
Substituted contract.
Yeah, right, sir. So Article 54 is the limitation period as far as suit for specific performance is concerned. What are the pleadings you make in a suit for specific performance, sir? How do you write the plaint as far as specific performance suit is concerned? If you are the plaintiff.
Srinivas Garu, can you
Hello,
explain
sir.
it?
What,
Yes,
what,
sir.
how-
Yes, hello.
what do you mention in the plaint?
Sir, in plaint, there should be mentioned that plaintiff is always ready and willing
You are
to
right. That
perform
is,
his part of contract.
that is section,
Hello,
section,
keep your mic little bit closer.
that is section 16. But apart from that, what are the valid essentials of a contract, sir? What all ingredients are there? Can you tell me, sir? Offer.
Plaintiff may claim that he has confirmed all the obligations. He has
Exactly,
done all
sir.
these contract with all the obligations.
Sir, that apart,
Whereas dependent has to.
don't you mention?
Dependent has.
Yes, sir. That apart, don't you mention that there was an offer, there was an acceptance, there was capacity, there was consent, there was consideration, and the object is also lawful. All the valid ingredients of a contract has to be specifically pleaded. Sir, you know this Specific Relief Act was amended in 2018. What is the provision that has been substituted in section 18? That is section 10. A particular word was removed and a particular word was substituted. What was that word that was substituted, sir? What was the word that was substituted in section 10 by the amending act of 2018? What was the word that was substituted and included, sir? The word that was substituted is the quote shall. The word may has been removed. Are you able to understand, please? So, in other words, normally when an agreement is placed before the court shall not exercise its discretion, but court shall grant specific performance unless the agreement is not proved. That is what is the amendment of 2018. So these are the few questions which I have framed. I'm really happy that most of you have responded to it. I mean, the next, because today is the first class. Today is the first class. I have only given you in the questionnaire form, and the same questionnaire form will 1 minute. Questionnaire form will continue tomorrow also, and then as far as the facts of the case are concerned, I'll give you the problems. You can solve it at your leisure, and then when we are on the Zoom, you can also explain to it, sir, because it's not possible for you to understand and immediately respond. Please remember, the one thing you have to avoid in court is you must avoid the court fear. Please remember, I am a capable person. I can present a case. I can place my case. I can win a case. I can succeed on the basis of my drafting. I can succeed on the basis of my evidence. I can succeed on the basis of my skill and experience. That spirit you have to develop. And please try to avoid shyness. And you have to be very, very bold, sir. The question is, if you are bold enough, the question is the other side cannot take you for a ride. But once you are slippery, the other side tries to take advantage. Don't fall into that particular trap. And please remember, if you are not thorough with English, try to go to the vernaculars and explain in Telugu. Sir, I'll give you the facts of the case, sir. You can answer it tomorrow.
We need the draft. Here is your things. We need a draft, and you should argue the case tomorrow by looking after your draft. You can argue the case. Present your things. This is happening case in our office. So we are giving a particular gist of the case. Please look into that. A client name. Sir? VR Kagar, please listen to our case gist so that you will be ready. We will take your Sarina madam. We'll take your questions. Please hold on. You're always on the move.
Give us 10 minutes time.
Please take the gist of the case. Are you ready, sir? All right. The name of the lady is Lakshmi. Uruf, alias. I'll call you alias. Priya. Why I put it in this way is, Lakshmi is called on a Aadhaar card, it is written as Lakshmi. But it was manipulated later on in Priya by a realtor by names Mr. Venkat and Swami. Two realtors are there in this. There's a sale agreement is being done in 2022. Agreement of sale. She has only received the consideration. Total sale consideration is about 60 lakhs. Okay, the amount paid is only 26 lakhs via cash and even including check amounts also. You can spill. I'll give you as per 5 lakhs has been cash. Rest of them are in part payments of 11 lakhs, which is 21 lakhs, which is left in checks. You can consider it one check or two check. It's your choice. Okay. Now coming to the gist of the cases, sale was done and an MOU is been given, saying that the checks which has been given will be given next 3 months. I will pay you in next 3 months. This is what the MOU is given in 2022. On what provision and how will you frame the facts of the case? How do you draft it? We need it. And most important thing is that on Aadhaar card, her name is Lakshmi. In 10th class also, her name is Lakshmi only. Only after getting married, she was written as Priya. She was written as Priya. Because her father-in-law calling her name in the house, it was registered on the name of on Priya also. It is not Lakshmi. Here is the practical issue now. Sale deed was done on Priya only. You understand the case gist? Anybody has any doubts?
Whether she married after 2002, sir? Or
yeah, she got married after 2002 only.
But sir, the sale deed was done on 2022, sir.
Yes.
As per the new norms of Registration Act, without Aadhaar card, we can't register any.
That is what. 1 second. At the time of Aadhaar card, when what she is doing it, she has done the same. This fellow has gone and created her name as Priya in Aadhaar card. And she has done the registration. But now the case has to be taken in such a way, her original name should be given and alias should be written as Priya also.
Yes,
on Aadhaar card. So you need to fight for her name as well as case also. Sale consideration also.
Okay.
Now I need a gist of the case to be written in a practical way in a draft. And how do you write it? Please mail it to my mail ID, advocatekalyan09@gmail.com. advocatekalyan09@gmail.com. Please.
Kalyan
09
09
@gmail.com. Please give the gist of the case in a practical person and draft it.
Okay.
This is a good opportunity because this is a typical case. It's a little bit complicated case. Wherein then the contract act comes. And a specific performance also comes in this particular aspect. I'm giving a clue. This is not a money suit. She don't have any kind of promissory note. She has only checks with an MOU. How do you file it? What are the documents has to be filed? What are all things to be filed? You have to write it clearly in the paper. Did you get the case, sir? Any questions to be asked? Please throw your questions so that I can answer you. Any questions?
Is that agreement made?
Sir, one by one, please.
The realtor is having something in his mind. He wants to take away the 26 lakhs and go away. So that's why he changed her name as Priya in the Aadhaar card.
You have to check for it. You have to check for it. That's the question I'm asking you. You have to do the draft. Everything, if I answer, how will you draft it, sir?
Read it for tomorrow.
I need a draft for tomorrow. All right, sir. Here we conclude the class for today. But I need the... Salina, your questions are here. 1 second. Sir, here is the question she has. What is evidence affidavit?
Evidence affidavit is, suppose let us say you have to come and depose before the court. Instead of coming and deposing before the court, whatever you have to state, whatever testimony you have to give, you write it in the form of an affidavit, that is a sworn statement of facts, and that will be in lieu of the evidence that will be that you will be giving in the court. That is called evidence affidavit. Are you able to understand, madam? Evidence affidavit is sum and substance of the case which you have plead, and what you would have deposed had you come personally to the court. And that affidavit will have to contain all the material particulars. That is what is called evidence affidavit. Yes.
And here one doubt, sir.
Yes.
In Kapil Sibal
Yeah.
was asked to produce an affidavit that
Yes.
he will uphold the Constitution of India
Yeah.
in the case of this Jammu and Kashmir issue case.
Yes.
The
370.
Chief Justice asked the Kapil Sibal before he argues, asked him to submit the affidavit that he will uphold the Constitution of India.
Right.
What does it mean?
It means that he will uphold the constitutional provisions. He will not disobey the constitutional provisions. He will submit his arguments or make his submissions purely according to the Constitution. He will not show any disrespect to the Constitution. He will not show any disrespect to the persons who have piloted that bill. He will not insult or annoy a person who has brought that bill, the party which has brought that bill in the court, before the parliament, and that he will objectively try to argue on those points without making any aspersions on anyone. That's the reason why affidavit is called for.
Are you clear with the question? Are you clear with the case gist which was given earlier? Are any questions on the particular? Please throw your questions. I'll answer you.
Sir, that problem which my admin had dictated to you, there's a twist in that, sir.
That they
One-
have
one
to,
minute.
no,
That's a-
no, no.
See, one thing
No.
the contents of the MOU did not tell you. He said the balance of the sale consideration has to be paid, and it will be paid in due course. And in case it does not pay, specific performance will be ordered. Then what will be the suppose specific performance is ordered? A sale which has taken place cannot be taken back. So whether that lady is entitled for return for the payment of that purchase money which she is entitled under the law. That's the question, sir. That's
So
the
I
point.
need a draft of the case particular on my mail ID. Please give it to me so that we will discuss on it, because he's already done with drafting and pleading. So definitely this question here which draft has been given, which will be useful for you.
That I'll still
Particularly,
that I'll still amplify, sir. The check was not given by the purchaser, but the check was given by the broker who intervened in the middle. And whether the broker and the person who was purchased are both liable, and if liable, what is the liability that can be cast on them? I'm amplifying it. I'm also giving you the answer.
he is amplifying the questions. I'm given a simple gist of the question. So any questions on this particular gist of the case? All right. 1 second. There is another question. She's very anxious about the question which she has asked. What is leave and license agreement?
Leave and license agreement is, suppose, let us say you got an open land, and the open land you for seasonal purposes you let it out, or you give permission to a person to vend his fruits or vend his crackers and all only for that particular season. You permit a person to occupy a particular land for a particular time, and after the purpose is accomplished, to return back the property and re-deliver the possession of the property. That is what is called leave and license. This arises mostly in the cases of temples, in the case of charitable institutions, in the case of mosque, where the pesh imam, the person who performs the prayer, is given free of rent accommodation, so long as he is the pesh imam of that particular mosque. And once he relinquishes office, he has to return it back. This is what is called leave and license. One more example I can give you is, suppose in the railway station you find lot of vendors there who are given who participate in the tender, and the tender is knocked down in their favor, and for that 1 year period they can sell eatables and confectionaries as far as the railway station is concerned, and they don't get a right in permanency, and their occupation is only temporary and depending on the will of the person who has given that license. Are you able to understand, please? So leave and license is not hereditary. It ends with the person. It is
Even
only for a
exhibition grounds.
temporary period.
Exhibition grounds are also same thing, right, sir?
Exactly, sir. That belongs to the exhibition society. But it's run by the exhibition society, the Numaish as they call it. It is run by the society. So the question of leave and license doesn't arise. But if you are putting up stalls there, only for the 2 months period you can have your stalls. You cannot have your stalls permanently there.
Even lease agreement is not permanent, isn't it?
But lease you get hereditary rights. You get a right of permanency so long as the lease is subsisting. But license it's not so. It is given for a specified duration of time. And once the duration of time is over, like bailment, you have to return back the re-deliver the property, possession of the property back to the person who has given you the license.
మీరు చాట్ బాక్స్ లో ఎక్కువ ఉంటారు సలీనా మేడం, ఆల్వేస్ ఆన్ ద చాట్ బాక్స్. ఐ am not able to understand. You should come out of your things and you should ask me what is a reciprocal promise.
Reciprocal promises, I make a particular promise to you. You in turn, that is what is called, of course, nowadays it's very, very common in political language, that is quid pro quo. I do something for you, you have to return it back either in cash or kind. That is what is called reciprocal promises. Unless both the promises are made, accepted, it does not fructify itself into a valid agreement. Are you able to understand, please?
All right, here we go. Please read it fully. Please ask me fully. మేడం చాట్ బాక్స్ లో అడగడం కాదు, మీరు కూడా ప్రత్యక్షంగా వచ్చి అడిగితే దట్ వుడ్ బి బెటర్ ఫర్ us. Always in a chat box. What is the reciprocal promise? Is it not reciprocal promise present in the every agreement?
So as far as reciprocal promise is concerned, when I make an offer to you, you also make a promise that you are accepting the offer and agreeing to pay the consideration, which is agreed upon by both of us. And one for a promise, there's an acceptance, and for an acceptance, there's a promise. That is called, and since the acceptor accepts it, you agree to sell the property to him, register the property to him, and also receive the sale consideration, and also deliver possession to him. That is, one makes a promise and the other person makes a promise, accepting it in toto and perform his obligation. Both the parties have to perform their respective obligation. That is called reciprocal promises.
Thank you. And I request for everyone, any questions, please come on online and ask us. Every question asked in this particular chat box may not be answerable. A practical approach is much more better for us. Please understand the situation. And you can ask live any questions also we have. This is a small request from my end, because there are a lot of questions are being asked in the chat boxes and through mails, through phone calls, emails, everything. So better you come out of that and ask in a practical way. We are here to help you out immediately. Thank you for the day. Yes, madam. Sir, Japan Srinivas garu, please.
Good evening, sir.
Good evening.
Sir, one small request and clarification requested is,
sir,
for an equitable mortgage, the period for filing a suit is 12 years under the Limitation Act, sir.
See, as far as, please remember, don't use the word equitable mortgage, sir. In 58F, you see, it is used, the word that is used is mortgage by deposit of title deeds. In India, we don't.
Yes, sir, mortgage by deposit of title deeds.
Don't use the word equitable, sir. But in India, we don't have equitable estates. Only in UK, you've got equitable estates. So 12 years period is there, sir, from the day when the money becomes due. That is Article 62.
What is asking an international question?
Article 62.
Srinivas garu, whatever you are asking is an international question, not in India.
One small request is that what has happened is that if suit is not filed, if mortgage suit is not filed within a period of 12 years, there is yet another provision of exercising the right till the period of 30 years.
So 30 years is only for the mortgagor, sir, not for the mortgagee.
Sir, you are not. We are. Ah, you got the point.
Yes, sir. Yes, sir. My client is mortgagor only.
Mortgage means 30 years provided your right is not extinguished. That is the mortgage.
And the property exists.
Again.
Sir, what is the meaning of that proper right not extinguished? That I could not properly follow.
Suppose the mortgage has already obtained a decree against you, or your right of equity of redemption has been extinguished by the court because you have not paid it within the time granted by the court, then no power on earth can save you unless you ask for extension.
Yes, sir.
That is Article 61 as far as mortgagor is concerned, Article 62 as far as the mortgage is concerned. And for recovery of possession of immovable property also it is 12 years.
Okay, sir. Recovery of possession also 12 years.
12 years.
So beyond 12 years.
Remember possession of immovable property. But as far as possession of movable property is concerned, it is 3 years. Why I am referring to that is your gold loans which are there, they are valid only for three years, not beyond that.
Okay, sir. 3 years only.
Yeah. For the movable property.
Yes, sir. Yes, sir. So beyond 12 years, the financial institution, suppose if it has lent mortgage loans and if no action is taken and if no decree is obtained within 12 years, the mortgage, the company, finance company will lose its right forever and ever.
I tell you how the finance company also loses its right. It is because of inadvertent handling of the case by a bank advocate. I still remember when you are appearing for a bank, when you have got a security, you don't mention about that security or don't file it under Order 34 for enforcement of mortgage. The question is date of mortgage, date and the documents are taken, everything you have to mention in a separate paragraph. And suppose you only file because you are in Hyderabad, you want to file the suit only in Hyderabad, but the property is at Nalgonda. You cannot file such a suit. You will have to go to Nalgonda and file it because you have to enforce the charge on the property at Nalgonda which is offered as security. And normally we advocates make a mistake when we write the prayer clause in the cause of action. I'm sorry. In the cause of action, it says the cause of action for the suit arose on so and so date when the defendant executed primary documents in favor of the bank, and also on so and so date when the loan advanced to the defendant was secured collaterally by deposit of title deeds belonging to the defendant on so and so date, and hence the suit is in time. And in the prayer clause, you say for recovery of rupees so and so, B for in default for enforcement of the charge by foreclosure or sale of the property. And then please remember, in a mortgage suit, 2 decrees are passed. One is for payment of money and another is for enforcing the charge. You must get a commission appointed, get the property sold, and then recover your money. But please remember, most of course, I'm sorry, sir, I'm not making any aspersion on any advocate. I myself was a bank advocate because the reason is sometimes the courts do not have that IQ which you have. You have to be very careful. When the institution trusts you, you must plead everything and you must go strictly according to law.
Yes, sir. Yes, sir. Thank you, Alan, sir.
Thank you. Any more questions?
Thanks.
All right. See you tomorrow again with the draft. We'll have a draft tomorrow. I am expecting a huge response from you so that we can go ahead with the practical exposures. Otherwise, we will only go with the theoretical. All right. Thank you much.
Sure, sir.
So, experiment.
Thank you, sir. Thank you.
We are just doing a small experiment beyond a theoretical knowledge. So please be cooperating with us.